Attorney and host of the podcast for the defense, David Oscar Markus. David, good to see you. First, I just want to start with what you think we can expect at Monday's arraignment.
You know, the arraignment's going to be very straightforward, other than all the press and pomp and circumstance. I mean, I think the prosecution has already messed up the case with the perp walk, with the overcharging. Remember, Jessica, everybody thinks this is an open and shut case based on the evidence. So there's really only two ways to mess it up. One is by overcharging. The other is by getting sympathy or jury nullification. And so, you know, by overcharging the case with this terrorism charge, I think they've given the defense a big opening in the case.
Okay, so I want to take a couple of those things that you've noted and drill down onto those. Let's start first with that perp walk, which we're playing video of right now. And a lot has been made of this because of how elaborate it was. The mayor is there. How many people are there? Does it tell us what legal doors this could potentially open for his team?
Well, the legal doors, not so many. I mean, there's no motion to file or a motion to dismiss or anything like that. Perp walks are done all the time. But I mean, this case is garnering a lot of sympathy on social media and other things like this. So to do the perp walk really falls into the defense's hands, falls into his idea of trying to garner sympathy at the trial, because people see these images and they start to feel bad for the guy, which is playing right again into the defense's hands, which is silly.
And then we have this whole issue where Mangione's attorneys thought they were going to go into state court. They ended up going to federal court at the last minute. Now there are state charges, there are federal charges. You mentioned the terrorism charge. Walk us through what all of that means. Is that standard, or is this different than we would typically see, to have both the federal, the state charges, and to have it kind of turned there at the last minute?
You know, the feds are not supposed to charge when the state charges. There's a policy against it. It's called the Pettit policy. It's not a binding policy, but they're not supposed to. But in high profile cases, you see it all the time as sort of a safety valve in case something in the state gets messed up. The feds want a piece of the action too. The problem with the terrorism charge in the state court, the problem with overcharging it, is a lot of times jurors react badly to that. And so you saw it recently in New York in the subway case, where they had to dismiss the top count during deliberations. This just happened and they didn't learn from their mistake. And there's a long history of it happening, Jessica. In the Terry Nichols, Oklahoma City bombing case, they overcharged it and Nichols was acquitted of first-degree murder. He was convicted of conspiracy. But when you overcharge a case, you run the risk of turning the jury off. And you just saw it in the New York subway case.
And federal prosecutors have not said yet if they will seek the death penalty. But how might that play a role in all of this?
Right. So it's really interesting. You have not seen a lot of Biden DOJ cases seeking the death penalty. We only have a few more weeks of that. I suspect under Trump's Department of Justice, we're going to see a lot more death penalty cases. And I suspect they will bring death penalty charges in this case in the feds. I think we're going to see a lot of it. And this case is sort of the prime example where the Department of Justice will seek it, especially under a Trump DOJ.
Yeah, that will be interesting to watch that play out. All right, David Oscar Markus, as always, thanks so much for your time. We appreciate it.
Happy holidays. Nice to see you.
You too.